You've probably already seen this video once, made for an American audience. Hold your license back, ask if you're detained or free to go, refuse to hand over anything until the officer answers. It's a good tactic in America. Copy it word for word at an Australian window, and the "don't show your license yet" part specifically can turn a routine stop into a real offense. Because in this country, producing your license when it's genuinely asked for was never optional in the first place. So here's what this video actually does. It keeps the part of the American tactic that's genuinely valuable, asking about your legal status out loud, on the record, and rebuilds it around what Australian law actually requires, using a real high court case about the exact moment someone doesn't know whether they're free to leave. By the end, you'll have a version of this question that gets you the same clarity without ever technically withholding something the law says you have to hand over. Quick word before we get into it. No invented authority on this channel. Just plain English Australian law, checked against the actual statutes and case law, every section sitting in the description below. Let's deal with the compelled half first, because this is exactly where the American version of this tactic goes wrong if you copy it here. In New South Wales, under Section 175 of the Road Transport Act, a driver stopped by police must produce their license when asked. Victoria and Queensland run equivalent duties through their own road safety and traffic legislation. This channel has said it in every video that's touched on this. No clever phrase erases a license duty, and a driver who announces he's withholding his license pending an answer to a question hasn't found a loophole. He's manufactured a second offense, on top of whatever the stop was originally about, in a country where the American version of this exact tactic simply doesn't have the legal footing it has overseas. But here's what does transfer, and it's the part actually worth keeping. The value in the American question was never the literal withholding. It was asking out loud, on the record, whether you're being detained or whether the encounter is voluntary and you're free to end it. That question has real legal weight in Australia too, just resting on different authority and delivered differently. At the same moment you're already handing your documents over rather than before it. The case worth knowing is Watson versus Marshall and Cade, decided by the High Court of Australia in 1971. A police officer asked a man to accompany him to a psychiatric hospital. The man believed that if he refused, he'd be compelled to go anyway, so he went. Later, he sued for false imprisonment. The High Court agreed with him. Justice Walsh held that his belief that he had no real choice was justified on the facts, and that the pressure created by the encounter itself amounted to imprisonment, even though no handcuffs were used and no formal words of arrest were ever spoken. The lesson sitting inside that case is exactly the one this video is built on. Ambiguity about whether you're free to leave isn't a neutral, harmless gap. Courts in this country have already held that an unclear situation, left unclear, can itself become unlawful detention. That's precisely why asking the question out loud matters here, with high court authority behind it, not because you copied an American script. Now the mistakes, because they're specific to this exact moment, and they run in both directions. Error 1, the one lifted straight from the American version without adjustment, treating the question as a condition you place before complying. "I'm not showing you my license until you tell me if I'm detained," sounds firm and protective. In Australia, it's the fastest way to convert a routine check into a failure to produce offense, because the compelled half of the stop was never conditional on getting an answer first. Error 2. Never asking the question at all, and simply assuming every stop that keeps going is automatically lawful. Watson tells you the opposite. An unclear situation can itself be the problem, and staying silent about that unclarity doesn't protect you. It just means nobody's put the ambiguity on the record. Error 3. Over-explaining once the documents are out. The driver who hands over a license and then keeps talking about where he's been, what he's doing, why he's in a hurry, has undone the entire value of asking a clarifying question in the first place by handing over voluntarily everything the question was meant to help him understand the limits of. Error 4. Assuming a polite, calm tone is somehow riskier than staying quiet altogether. It isn't. This channel has said it in every video that's touched on this moment, because the officers who've actually studied de-escalation know the difference too. A level, unhurried question changes nothing about how cooperative you appear on camera, and everything about whether the encounter's legal status ever gets put on the record at all. So here's the phrase, built to ask exactly what the American version asks, without ever creating the gap it creates when copied literally. Here's my license, officer, as required. Am I being detained, or is this a routine check, and I don't consent to any search? Say it again, slower, because the second pass is the one that actually stays with you. Here's my license, officer, as required. Am I being detained, or is this a routine check, and I don't consent to any search? Every clause is doing a specific job in a specific order. Here's my license, officer, as required, satisfies the compelled half completely, in the same breath as the question, so there's no gap for a failure to produce charge to live in. Am I being detained, or is this a routine check? Is Watson's principle spoken out loud. You're not challenging the officer, you're closing the exact kind of ambiguity the High Court has already said can amount to unlawful detention if left open. I don't consent to any search does the separate job this channel has already covered in earlier videos, closing off the easiest route into your vehicle, your own agreement, regardless of how the detention question gets answered. Picture the whole exchange. Window down, you reach for your license as the officer approaches. Here's my license, officer, as required. Am I being detained, or is this a routine check, and I don't consent to any search? He glances at it. Just a routine check, mate. Going around checking Rego. He hands it back. No worries, drive safe. Window up. Nothing in that exchange was defiance, and nothing in it was withheld. You complied with everything genuinely required. In the same breath, you asked the one thing worth knowing. It's worth sitting with Watson a little longer, because the reasoning behind it explains why this channel treats the question as genuinely protective rather than just a nice thing to say. The High Court wasn't looking at handcuffs or a formal arrest. It was looking at pressure. The ordinary unspoken pressure of a uniformed officer making a request in a way that left an ordinary person reasonably believing they had no real choice but to comply. That's the exact texture of a traffic stop that keeps running past its original purpose without anyone naming a reason. Nobody's raised their voice. Nobody's said the word arrest. And yet the ambiguity itself, left unaddressed, is precisely the thing Watson says courts take seriously. There's a second, more recent Australian case worth knowing alongside it, because it shows the flip side of the same coin. In State of New South Wales versus Exton, a 17-year-old was told to get out of a car, was awarded damages at trial for false imprisonment, and then had that finding overturned on appeal. The Court of Appeal held that a direction to exit a vehicle, on its own, without more, isn't automatically an arrest or a detention. The status of the encounter has to be assessed on what was actually said and done, not assumed from one instruction alone. Read both cases together, and the principle becomes clear. Detention isn't announced with a specific phrase, and it isn't ruled out just because nobody used dramatic language either. It has to be worked out from the actual substance of the exchange, which is exactly why asking the question directly and getting an answer on the record removes the guesswork a court would otherwise have to reconstruct after the fact. A word for whoever's sitting in the passenger seat, because the same ambiguity Watson addresses doesn't stop at the driver's door. If an officer asks a passenger to stay put, or implies through tone or positioning that leaving isn't really an option, the same clarifying question works from that seat too, and for the same reason. Am I being detained, officer, or am I free to go? Costs a passenger nothing to ask, and removes the same kind of unspoken pressure Watson found unlawful when it was left to sit unaddressed. Now, about the questions that go beyond the document check. Where you've been, whether you've been drinking, what's in the car. This channel has already built an entire video around exactly this, anchored in Petty and Maiden versus the Queen, the High Court ruling that there's no legal obligation to answer police questions and that silence alone can never become evidence against you. That protection still applies here, in full. What doesn't transfer from the American version is the specific wording, "I'd rather not answer questions without a lawyer present." In Australia, your right to decline those questions doesn't depend on a lawyer being present, and framing it that way can actually undersell a protection you already have unconditionally. You don't need to invoke a lawyer to stay silent on a voluntary question. The simpler, stronger version is just, "I'd rather not answer that." No lawyer required to make it valid. There's also a genuine Australian equivalent to the American principle that a stop can't be dragged out indefinitely once its original purpose is done, even though it doesn't come from one single famous case the way it does in the United States. Search and detention powers under LEPRA and its state equivalents are consistently written around the words "reasonably necessary," meaning the exercise of any power is meant to last only as long as its actual purpose requires, not indefinitely, and not as a fishing exercise once the original reason has been resolved. If a license check comes back clean and the stop keeps running with no new ground named, that's the moment to ask the same clarifying question again, calmly. Am I still being detained, officer, or am I free to go? You're not being difficult. You're applying the same principle Watson already established. An unclear situation doesn't get to stay unclear just because nobody asked. That reasonably necessary wording isn't just a phrase this channel likes, it's a genuine recurring drafting choice across Australian police powers legislation, and it's worth understanding why it was written that way rather than as a fixed time limit the way some American rules are. A fixed limit is easy to apply but easy to game right up against the edge of it. A reasonably necessary standard asks a court, after the fact, to look at what the power was actually for and whether the time taken matched that purpose, which means the exact number of minutes matters less than whether anything genuinely new was being investigated during that time. A license check that's finished, followed by 10 more minutes of general conversation with no new ground named, is precisely the kind of gap that standard was written to catch, even without a single famous case, putting a number on it the way Rodriguez did in the United States. The trained officer has two common ways of responding when this question gets asked, and neither should throw you off the calm, complying tone that carries the whole exchange. Sometimes it's answered immediately and plainly, "Just routine, mate," and the stop proceeds exactly as it would have anyway, just with the status now clear and on record. Sometimes there's a pause or a redirect. "Why? Do you have something to hide?" "You don't take that bait." Same words, same level. "I understand, officer. I'm complying. I'd just like to know if I'm being detained." Nothing about asking a calm, factual question, once, is confrontational, and nothing about it gives an officer grounds for anything he didn't already have. Now the version of this that doesn't end quietly, because a channel that only shows you the easy outcome isn't preparing you for the real one. Same opening. "Here's my license, officer, as required. Am I being detained or is this a routine check, and I don't consent to any search?" Instead of a quick answer, the officer keeps checking your details in silence, doesn't confirm anything, and the stop keeps running. A few minutes pass. You ask again, calm, unhurried, "Officer, am I still being detained, or am I free to go now?" If he names a real, specific reason at this point, an outstanding warrant showing on the system, a genuine basis to suspect something tied to the original stop, that reason changes what's happening, and you comply with whatever's actually named. If he simply waves you off without answering, that non-answer is itself worth remembering accurately afterward, because Watson's entire holding is that an unclear situation, left unclear, is the exact thing a court can later find unlawful. One last practical note, separate from anything said in the moment. If a stop runs long without a clear answer to this question, note the time you first asked it, the time you asked it again if you had to, and whatever response you actually got as soon afterward as you safely can. Watson protects you in principle by making ambiguity itself a live legal issue. A written record protects you in practice if the actual length and nature of that ambiguity is ever revisited by someone who wasn't standing at the window with you. A genuine state-by-state note, because the specific license production sections differ even though the underlying principle from Watson applies nationally, as High Court authority always does. New South Wales runs this duty through Section 175 of the Road Transport Act. Victoria and Queensland run their own equivalents under their own road safety legislation. What doesn't change at any border is the value of asking, clearly and calmly, whether you're detained, because that's a high court principle, not a state one, and it travels with you no matter which plate is on the car. To close it out, the American version of this video isn't wrong to value clarity about your legal status. It's wrong for an Australian audience only in the order it puts things. Here, you don't withhold what's compelled to get that clarity. You ask for it in the same breath you comply, and Watson versus Marshall and Cade already tells you why that question matters. An unclear situation, left unclear, is exactly the kind of thing Australian courts have already called unlawful. Comply with what's genuinely required every time, no argument. Ask what your status actually is, calmly, every time. And decline the search separately, in the same breath, because none of the three steps ever needed to wait for the other two. This is general information, not legal advice, and the specific sections governing license production shift at every state border. Check the ones that apply where you actually drive. If a stop goes further than a conversation, the video ends and a lawyer begins. Legal aid exists in every state. Share this with whoever's already tried the American version of this tactic here and got more trouble than clarity out of it. The mate who proudly refused to hand over his license and ended up with a second charge for the trouble. Tell me in the comments, have you ever been unsure, mid-stop, whether you were actually free to leave? And did you know a high court case had already ruled on exactly that feeling? Subscribe for the next stop, because next time, it isn't your license they're asking about. It's the phone in your pocket. That video's coming next.